the Department of International Relations. Welcome to this meeting. I think some members will still join us. As I indicated earlier, that we were in a previous committee meeting, a committee on petitions. But be that as it may, just indicate to honourable members that we did receive an apology from Minister Pando, in that she's attending an executive council meeting of the African Union. But Deputy Minister, we have engaged with you previously when we dealt with the Treaty of Amity and Cooperation with the Association of Southeast Asian Nations. And it was in that meeting that we also took a decision to further engage with the department. And indeed, in today's engagement, we would want to have a deeper and clearer understanding of the processes involved in treaty making in the country. We would also possibly discuss modalities for enhancing the current mechanisms of scrutinizing treaties and obviously enhance oversight on the implementation of these treaties. Members, we called upon the Department of International Relations and Cooperation to brief us on the current practice with regard to treaty making processes in South Africa, and being the National Council of Provinces and our interest being on provincial matters, we've also asked the department to brief us on what I guess we termed at the time city twinning agreements entered into between our provincial and municipal authorities with their foreign counterparts. And I think it's important that we understand the processes on this category of international agreements as they affect our oversight area. And we also need to understand the impact on the coordination mechanisms endorsed in Cabinet and the extent of their enforcement in international law. So that I think as we move forward, it will also enable us to devise a complementary oversight strategy on this category of agreements in our country. Our members, I think in terms of the agenda, it was sent to members, but in essence, as I've indicated, we will receive a briefing and the department will cover the two aspects, the one being the process followed for the ratification of bilateral and multilateral agreements, and the second being the nature and coordination of city twinning agreements with foreign provinces, legislatures, and municipalities. And thereafter, honourable members will have an opportunity then to engage on the presentations. Honourable Deputy Minister, I must also just indicate to you that we're having a bit of a meeting marathon day. You know, we're moving from one meeting to the next to the next. I'm sure you're used to that kind of life. But yeah, so I think we can then maybe perhaps just get into the presentation, and then as various members of this committee, we will engage your presentation. Thank you. Over to you, Deputy Minister, and you may want to perhaps also introduce your team. But I think that you met us before, so you know, you should know us by now. But okay, but maybe in that instance, perhaps any person or any member of the committee or any official of the department, when you do speak, perhaps just introduce yourself at that time. Deputy Minister, over to you. Thank you.
Thank you very much, Chairperson. You, like you said, you are pressed up on time, so we were supposed to present our opening remarks in a form of presentation so that we simplify the technical presentation. I don't know whether it is still in order in that manner.
No, please, Deputy Minister, we do have time for that. Please continue with your presentation the way you planned it. I'm just saying that let's get into it.
Okay, thank you very much, Chairperson and honorable members. Allow me on behalf of the Minister of International Relations and Cooperation, Minister Pando, to thank the Select Committee on Security Justice for the invitation and the opportunity to engage the committee on the processes for ratification of bilateral multilateral agreement in South Africa. The committee also expressed the wish to engage the department on the conclusion of city twinning agreement with foreign provinces, legislatures, and municipalities that the committee identified as areas of concern which impact upon its mandate. This is also an opportunity for members to familiarize themselves with some of the operations of the department. Your invitation, Chairperson, is indeed welcome at a time where international relation and cooperation among states during and now that the world is moving into a post-COVID era is more important than ever. As states were reminded by the pandemic that they need each other for support and to rebuild their economies to the benefit for all, large and small nations alike. Close cooperation between states will be essential in order to assist each other in these efforts, and here international agreements are of particular importance. International agreement, Chairperson, are the tool through which international relations are given substance, and it creates legally binding obligations between the parties thereto. This agreement forms the basis for an international rule-based system that is necessary to ensure peace, security, and prosperity for all nations. International agreements, bilaterals and multilateral in nature, play a strategic role in the advancement of South Africa's national priorities and foreign policy objectives as articulated in the National Development Plan Vision 2030 and African Union Agenda 2063. The terminology used to describe international agreements are varied in and cover a wide spectrum, including the titles, treaty, convention, protocols, and memorandum of understanding. These are all international agreements and binding upon the parties thereto in terms of international law. Bilateral agreements, which are concluded between two states, deals with a wide number of subjects. For example, cooperation in the area of health, education, mutual legal assistance, extradition, double taxation, defense, culture, sports, and protection of investment. Multilateral and regional agreement, on the other hand, establish legal obligations amongst a broad spectrum of nations, and some are binding on all states. These type of agreements are used to achieve various objectives. Some establish international organizations such as United Nations, African Union, SADC, the European Union, and the Pan-African Parliament. Others create regulatory regime to regulate specific matters such as international trade, human rights, environment, and disarmament, to name but a few. Examples that came to mind are, for example, the African Free Trade Agreement, the International Convention on Civil and Political Rights, the Refugee Convention, the African Nuclear Weapon Free Zone Treaty, the United Nations Law of the Sea Convention, and the Paris Climate Change Agreement. All international agreements, by whatever name, is legally binding in terms of international law when a country becomes a party thereto. The international arrangement that provincial and local government conclude with their counterpart abroad do not constitute international agreements that are legally binding in terms of international law. These arrangements are also described in a variety of ways, including cooperation agreement, city-to-city agreement, and twinning agreement. These are focused on the local need of state, province, and local government, and are directed at establishing and promoting partnership between South African provinces and municipalities, and provinces and municipalities across the world in order to create an environment for closer cooperation on provincial and local government level. Some of these arrangements, in fact, also constitute private law government contracts that are enforceable by both parties. The competency to conclude international agreement is regulated in terms of the Constitution. It is important in this regard to recall that there are three spheres of government in South Africa, and that the Constitution empowers the national government with the mandate of concluding international relations. The Constitution provides in Section 231 that the negotiation and conclusion of international agreements rest with the national executive. The national executive exercises this responsibility on behalf of the whole of South Africa. Parliament has also an important role to play in terms of the Constitution in respect of the conclusion of international agreement, where such agreement require to be ratified or ascended to in order to become a party thereto. It is only Parliament that can approve that South African ratifies or accede to an international agreement, and equally when South Africa decides to withdraw from any international agreement which requires parliamentary approval in the first place. On the other hand, the Constitution does not grant the competency to conclude international agreement to provinces and local governments. The arrangement concluded by them are not governed by international law. Provinces and local governments can also only conclude arrangements in respect of those areas where the competencies for a particular area have been assigned to provinces and local government under Schedule 4 and 5 of the Constitution. As South Africa is a unitary state, it is essential that all our efforts in the area of international relations are focused to attain and to support the foreign policy objectives of government. This must be done through close coordination between the three spheres of government to lessen the negative effect of fragmentation of South Africa's international relations. Inevitable, such fragmentation leads to lesser effectiveness and impact in what we as a country desire to achieve. It is thus essential that when provinces and municipalities want to pursue international engagements, that this must be done in synergy and in support of South African national interest and developmental priorities. As the Department of International Relations and Cooperation is responsible for the implementation of South Africa's foreign policy and the conduct of international relations, it is the entry point for all matters relating to the international engagement by national, provincial, and local government, as well as by other institutions of state. In terms of its constitution, South Africa has an obligation to comply with its international obligations that flow from international agreements and customary international law. The consideration and conclusion of international agreements cannot, therefore, be done lightly, as it has implication for South Africa. South Africa often finds itself lacking in the area of the implementation of the international agreements, already concluded, which creates problem for the relationship with the countries with whom these agreements have been concluded. We also do not always capitalize on the benefit and opportunities that can flow from international agreements on the benefit of our people. South Africa has over the years concluded 2,419 bilateral agreements and 744 multilateral agreements. National government is currently making an assessment of the benefits that are derived from these existing international agreements and whether the benefits are optimally utilized. Provinces and local governments should focus their effort to establish cooperation with their counterparts on existing international agreements concluded by South Africa, through which they can localize the implementation of the agreements and the opportunities that are available. In order to achieve this, improved communication and coordination is key. The lack of proper coordination was recognized and has now been addressed in the new Foreign Service Act that was passed by the National Assembly earlier this year. It established a permanent forum in the form of a consultative forum on international relations, which will be a similar forum that those established under the Framework for International Governmental Relations Act. This forum will provide focus, direction, and cohesion amongst all three spheres of government to identify the areas where international cooperation are needed, to link activities with existing agreements and identify areas where agreements are still needed to open opportunities through which the best solution and expertise can be sourced. It will also identify areas where South Africa can provide support and assistance to other countries. The South African treaty section within the department is the official custodian of all agreements that South Africa is a party to, which also conclude a list of provincial and local government arrangements. Unfortunately, the list of provincial and local government arrangements is not complete as it is compiled on the basis of the information that provinces and local governments submit to the treaty section. The South African Treaty Register is the official record of all bilaterals and multilateral international agreements that South Africa is a party to. The register is in electronic format and updated daily with data pertaining to the status of international agreement. This information is accessible via the internet or obtainable by request sent to the treaty section. In this regard, Chairperson, I'll request our officials who are in the system now, who are connected now, to make a technical presentation, and we are prepared to answer all questions that the honorable members may have for us. I thank you.
Thank you, Deputy Minister. If your officials can continue with the presentation.
Good afternoon, Excellencies, Honorable Minister. This is Sandhya De Wet, Chief State Law Advisor in the Department of International Relations and Cooperation. I have with me this afternoon Ms. Rika van der Walt. She is the head of the treaty section, and we really appreciate the fact that we have this opportunity to engage and to brief you on the technical aspects. I see that the presentation is on the screen already. I think Deputy Minister has already talked about the role of international agreements. I would ask that we move to slide 4, please. As we all know that we are three spheres of government in South Africa in terms of our constitution. The constitution, where it specifically deals with the conclusion of international agreements, specifically places this obligation on the national executive, who exercise this responsibility on behalf of the whole of South Africa. Next slide, please. Now, as Deputy Minister has indicated, there are many terms for an international agreement, but the main instrument here that should guide us when we determine what is an international agreement is, of course, the Vienna Convention on the Law of Treaties that is applicable to South Africa, and it's customary international law. It is actually universally accepted by all states. And here the important aspect is it's always a written agreement between states. That's, in other words, not provinces or even federal states, but states with sovereignty. And it is governed by international law, which is very specific. Now, the terminology that Your Excellencies would have heard before would be a treaty or convention, agreement, protocol, a memorandum of understanding. Our constitution specifically uses the terminology of international agreements. That is a very universal description of all of these above. Treaty is a form that would usually be used for a very formal arrangement like a peace treaty. A convention is usually a multilateral agreement that will involve most countries in the world. Agreement, many countries prefer the word agreement, and that's for bilateral and multilateral agreements. And the protocol is very often an instrument which is dependent on a treaty or an agreement. In other words, it is linked to that. You would get the United Nations Climate Change Convention, and then you would then get protocols under that convention, like the Kyoto Protocol, just as an example. There's also a vehicle that we use that we called exchange of notes. That is also a type of an agreement where the parties are not able to be together, and the agreement will then be formalized in the forms of exchange of notes. That means that the one party will present to the other party in notes, diplomatic notes, the content of the agreement. The cabinet consists of the president, a deputy president, and the ministers. So the executive, the national executive that are responsible for concluding international agreements is indeed then the president and the cabinet ministers. Therefore, when you see a cabinet presidential minute, and that is the instrument where the president would in writing declare the South Africa's intention to sign the agreement and give authority for a particular minister. It's always signed by the president and the minister responsible for the subject matter of that agreement. Next slide, please. Now in section 2312, it specifically then goes into more detail to say international agreements bind the Republic of South Africa after it has been approved by resolution in both the National Assembly and the National Council of Provinces. And then what we're saying here, unless it is an agreement referred to in subsection 3, which we will come to now. So this specific article then provides Parliament with the duty and the responsibility to then confirm and to look at the agreement and then to decide by way of resolution that South Africa will indeed become a party to that. These types of agreements would require ratification or accession. There's usually multilateral agreements where there's a specific article in that agreement that provides that the agreement will only become binding on the party when that party has either ratified it or either have to deposit an instrument of accession. And this is where Parliament is the only body that can actually approve ratification or accession. The types of agreements that will go to Parliament are therefore multilateral agreements, agreements. There's also bilateral agreements that might require ratification or accession, and that will depend very much on the counterpart. Some of the counterparts' constitution require that all their international agreements must be ratified. In our case, we would then include a section where we note that our constitutional procedures will be followed in such cases. The agreements that have financial implications that require additional budgetary allocation of Parliament are also agreements that need to be submitted to Parliament. And of course, those agreements that have legislative or domestic implications, in other words, that require new legislation or legislative amendments, need to come before Parliament before it can enter into force. Next slide, please. The next slide talks specifically about technical, administrative, and executive agreements. And these agreements are those that do not require either ratification or accession. They are entered into by the national executive, and it binds the Republic when it is signed. Without the approval of the National Assembly and the National Council of Provinces, but the requirement is that these agreements must all be tabled in the Assembly and the Council within a reasonable time. As I said, these agreements do not require ratification and accession. There's no budgetary financial implications for it. There's also no legislative implications. And the only requirement then where Parliament will have an oversight role is when these agreements are tabled. And it needs to be tabled within a reasonable time. And in a recent court case, the court indicated that a year is a reasonable time for tabling in Parliament. So departments cannot sit on these agreements, must be tabled so that members of Parliament can have a view of that. Now, Section 2312 that needs ratification on accession also need therefore presidential approval. How the process will work is the parties will negotiate amongst each other. They will then come to an agreement on the particular text. That text is then submitted through the legal procedures. It goes to the Department of Justice. It comes to the Department of International Relations, where we will then grant or issue legal opinions. We will also be required to certify the agreements. You would know that in case of legislation, the legal advisors of the Department of Justice is required to certify legislation. Similarly, our department is required to certify international agreements. The President will not approve any agreement without that agreement being certified. So then after the signature of the agreement, the process to obtain parliamentary approval will begin. All agreements that require parliamentary approval must be submitted to Cabinet first for discussion. Cabinet then makes a recommendation regarding the accession or ratification and approves that the agreement can be then presented to Parliament. If there are any reservations to international agreements, that is also then provided for by Cabinet. Reservations are usually allowed when an agreement deals with a particular topic where it is clear that not all parties will be able to implement particular sections or parts of the agreement. And those are then usually specified to say that you can become a party, but you can make reservations that a particular section or an article in a treaty is not applicable to you, although you are a party to that agreement. It is these days not often that we see that, but some of the older agreements very often had such provisions. So then the procedure for ratification and international of the agreements, the tabling of is the responsibility of the line function department. So once Cabinet has approved that the agreement can be submitted to Parliament, it is then tabled by the line function. If it's environment, it is done by environment. If it's defense, it's done by defense, for example. So how does that process work? The ministers responsible for the particular department will send letters requesting the tabling addressed to the Speaker of the National Assembly and the Chairperson of the National Council of Provinces. The agreement will be tabled in the announcements, tabling and committee reports of Parliament, and then it is referred to the relevant portfolio and select committees. And lastly, it is approved in the minutes of the proceedings of Parliament when the whole process has been concluded. Both houses of Parliament have to approve ratification and accession of international agreements. It is not enough only for one house to approve. Both houses, in terms of the Constitution, needs to approve ratification or accession. Next slide, please. Once the approval has been obtained by both houses for ratification, then it will happen then on the international plane. So domestically, we will have Parliament's approval for ratification. Now we need to process that process to the treaty body responsible for this particular agreement. And this is then done through the depositing of an instrument of ratification or accession with the organization or the specific country that has been appointed in the treaty or the agreement to accept these instruments. Instrument of ratification and accession is signed by either the President or the Minister of International Relations. It is not signed by any other minister because the Vienna Convention on Treaties specifically acknowledges the President and the Minister of Foreign Affairs as an official representative of a country. So that is also something that is done by the Minister of International Relations. I just want to say the act of ratification should not be confused with what is required at the national level. Each of all states will have their own constitutional provisions that are applicable, and so there might be situations where on a national level ratification is needed, but we are talking here of matters where the Constitution requires Parliament's approval for ratification. Next slide, please. So the procedure to be followed by in terms of administrative and technical agreements are the same, although these agreements are not necessarily engaged with in cabinet. The President and the minister responsible would sign the President's minute. After all the negotiations have been concluded, the parties have agreed on the final text. And then those agreements are tabled for information purposes as I said, in the announcement tablings and committee reports of Parliament. Then on to the South African treaty section. As Minister has indicated, this is the official custodian of international agreements. If we say custodian, it is the section is responsible for safeguarding and safeholding and recording of all international agreements that South Africa is a party to. Minister has also alluded to the fact that there's a large number of agreements, and those are all housed. The physical copies of that are all in a safe that we call the treaty safe. There are particular international, shall I say, regulations that apply to your treaty collection, and that is followed by South Africa very closely. These agreements, the treaty section, when they get these agreements, they bind the agreements in a particular folder, the official folder. And I'm sorry that I'm not able to show you such a folder, but I'm sure you have seen them. And it's sealed with actual wax. And there's a lint that are also waxed into the cover. And that is just one of those old traditions of international relations to make sure that no one can remove a page from that agreement, because then immediately you will break the seal. The agreements are then signed once sealed when they are presented either at the signing ceremony or by National Commission. They are then signed by the particular ministers. Those agreements or president, those agreements are then deposited at the treaty section, and the treaty section is therefore the depository of all international agreements signed by South Africa. They also maintain, as Deputy Minister has indicated, an up-to-date electronic record of the status of agreements. These agreements are publicly available. They provide access to treaties and treaty information. So if anyone has a question about the existence of a treaty or a copy of the treaty, these are this is the place to get that. And this is the official information. There are lots of websites with lots of agreements out there, but they are not official. And what you get on those websites are not necessarily reflective of the true situation. Now, the next leg is that all agreements that South Africa is a party to, regardless whether it's bilateral or multilateral agreements, are registered by with the United Nations. They have a very big treaty collection that consists of all nations' treaties, and they then capture those treaties. We are in all of these processes. We are guided by the document called Guidance on South African Treaty Practice, and all of these are available at the website that is on your screens. Of course, our treaty officials are also available for any questions and any requests. Turning then to provincial and municipal arrangements, as Minister has indicated, provincial and local governments do not have the competency to conclude international agreements. They conclude agreements with international role players, but there is a difference between what is an international agreement and what is concluded by provinces or local governments. Usually what we see in practice is that provinces would conclude documents that they call memorandum of understanding or arrangements. They conclude contracts, which of course is something that we also see that sometimes you have a mixture of an arrangement and the contract. Back to the first slide, to the other slide, please. So it is the twinning agreements, and all of that are not governed by international law. These types of agreements must fall within the areas of competencies that are given to the provinces and are reflected in Schedules 4 and 5 of the Constitution. And it should be very carefully considered that these types of agreements are not going outside those parameters. We have seen that also in our engagements with these agreements, that some of them fall outside of their competencies. As I said, that are the types of documentation that we see. A twinning agreement is an informal arrangement indicating the mutual intentions and goodwill between either cities. We have seen some provinces even concluding twinning agreements where there is a connection between a province of another state and a province in South Africa where they believe that there are a need for closer cooperations. Next slide, please. What we have also is a set out procedure to be followed before signing arrangements. Unfortunately, I must be upfront to say that this is not very closely followed by all provinces. Some provinces are better than others in following these arrangements, and it might be for various reasons, including that the provinces might not be fully aware or the officials that are responsible for these matters are not fully aware of these requirements. What needs to happen is that all of these arrangements must be deposited with what we call in our department the Directorate of Intergovernmental Provincial Protocol. They would then, that unit is a unit in branch protocol in DIRCO, and that unit is responsible for the liaison between the province and the responsible desk in DIRCO. If we take an agreement, we take an example for Brazil, say it is an agreement between KwaZulu-Natal or or Gauteng and Brazil. The documents will then be submitted to the Intergovernmental Provincial Protocol Desk. It would then be escalated to our political desk responsible for Brazil. That directorate or the provincial directorate would get a legal opinion from our office and not from the Justice Department, because this is not an international agreement. We would assist in scrutinizing the text to make sure that it is in line with what is required from an international point of view, and make sure that it does not contain international law implications. Next slide, please. And then, of course, the provinces will then conclude those agreements once we have looked at that and approve those agreements, or the text of those agreements. There has been an understanding that has been for quite some time. In 2009, the body that the minister referred to as a coordinating body for international relations, that we call CIFR, is issued guidelines in 2009 to all provinces and local governments, indicating that these instruments must be the copies must be deposited with the treaty section. We will keep a record of those, and there is a database, the register, and that register is available, and it's an important document, as it is available to the provinces for planning purposes, for coordinating, for harmonizing and improving service delivery. Unfortunately, we must also say that these guidelines, 2009 guidelines, are not very thoroughly implemented. We do not see a lot of agreements from provinces, although we are aware sometimes, and we see sometimes in the press, that there's been agreements that have been concluded. Again, these are accessible on our website. We have, just to give you an indication, and we believe this is a number that are totally unreliable. We have captured 176 arrangements, provincial and local government arrangements. 70 are on municipal level and 106 on provincial level. Now, we know as a reality that those are not giving the full picture. We want to specifically, Minister also have alluded to that fact, specifically deals with the benefit of better coordination amongst the three spheres of government. We must understand that South Africa is a unitary state. In other words, the provinces are not like federal states with their own autonomy on international relations. They have other kinds of autonomy and other kinds of competencies. And coordination between national, provincial, and local level is therefore essential. We need to improve our communication between these three components of governments, especially as they relate to existing international agreements, because existing international agreements can give a framework to all provinces on which to build, and provinces can then build their arrangements on the basis of those agreements. And what we often see is that there is a discrepancy or a total lack of even awareness that there might be an international agreement on a particular area, and we see provinces putting a big effort into attaining exactly that. So it is important that we use the general cooperation agreements. We have many cooperation agreements with almost all countries in the world that makes provision for cooperation on a vast spectrum of areas, subjects, and those needs to be drilled down by the provinces and to see how they can benefit from those agreements. They can then also, of course, leverage those agreements to so the benefits of those agreements for their provinces. Next slide, please. These arrangements can also link with existing donor agreements. There needs to be an identification whether whatever wants to be achieved by a province cannot be met by the existing international agreements, and for that there needs to be a discussion between the province and the national department responsible for that agreement to see how cooperation can then be be made more effective, and that the particular province's needs can be met through the implementation of those agreements. It is important that provinces, and this is also for South Africa at the national level, to only conclude agreements where there's really a need for such agreement, and not just to show that there's some type of outcome of engagement. I think we need to use these tools much more strategically. It is also important that the best solution or expertise are identified that is around, and then to see where that can be sourced, so that we do not have a situation where we conclude agreements with countries that are unable to provide the solution that is required. And the same with South Africa. If we do not have expertise in or what we can offer internationally, it is not wise to conclude an agreement and to say that we will provide those expertise if we do not have that, or whether it will overstretch the country and we need that expertise rather on to focus nationally. Then, as I said, this close coordination needs to happen. There is the forum that is established. It is called Consultative Forum on International Relations. The department convenes this forum for many years already, and all provinces and local governments, SALGA, and sometimes of the big metros are, not sometimes, the metros are in any case invited, and then representatives from local government through SALGA. They then attend these meetings, or are supposed to attend these meetings of CIFER, where all of these matters that I highlighted now are addressed, and the whole idea is closer coordination to be achieved. Now, as Minister has said, this forum has been formalized in the new Foreign Service Act, which the President has signed, and which is still awaiting an entry into force date. And we hope that through this forum, provinces will then have an opportunity, and national departments to have a forum for better engagement, because we do believe that there is currently sort of a divide between national government responsible for particular areas and provinces in this particular area of the conclusion of international arrangements by provinces. Thank you, Madam Chair.
Thank you. Deputy Minister, do you have anything else to add?
Thank you very much, Chair. We will wait for the members' questions.
Yeah, thank you very much, Deputy Minister, and your team for that presentation. I think clearly it's quite informative in that it enhances our understanding on procedure, but also on the differences in terms of international agreements at the national level, as well as the different type of arrangements that happen in provinces and with municipalities. Our members, this session is pretty informative. Is there any indication that you would want to ask, any questions of clarity? But obviously, being an oversight body as well, you're welcome to also raise other issues. If I can get an indication from honourable members, if you have any questions you would like to raise.
It's Honourable Bartlett.
Okay, I've noted Honourable Bartlett. Are there any other members? Okay, Honourable Bartlett.
I'm trying to do the raise your hand. I'm failing. Can you also note me, Chair?
Fine, Honourable Nwita.
Thanks.
Okay, I'll start then with Honourable Bartlett. Honourable Bartlett?
Yeah, no, I don't love Honourable Nita, sorry, because I'm also struggling sometimes, Honourable Nita. No, Chair, it's really informative presentation. Was really thank the Deputy Minister. But I just want clarity on the section 231.1, because I didn't follow that process. Section 231.1. Just clarity on it.
Thank you.
I'm not clear, my clarity.
Thank you, Honourable Bartlett. Honourable Nwita?
Thank you very much, Chair. Chair, on my side, I just want to know, I heard the presentation saying, Chair, the presenter, especially the last presenter, saying, Chair, they have a directorate that deals with international protocols. I just want to know, what is the relationship of that department with provinces as well as municipalities? I'll tell you why I'm asking the question, Chair. I am not sure if municipalities, when they form their partnership with some of the countries or else memorandum of understanding, they are adhering to some kind of protocols nationally, because you just hear the municipalities has gone into a certain country, they form partnership with a certain municipality. I do not know if when that is going to happen, is that particular directorate interacting with municipalities and giving them guidance as to what are the do's and don'ts in terms of their partnerships. That's what, Chair, I wanted to ask.
Thank you, Honorable Nita. Any other member? Okay, if there's no other member that would want to make a comment or ask a question of clarity, perhaps I should just raise a few issues as well. I think, Deputy Minister, when in your opening remarks, you did speak about capitalizing on benefits and opportunities in terms of international agreements. I know while today we're focusing more on procedure, we're also interested in the impact of these agreements or these arrangements. And you mentioned that as national government, you would be doing an assessment of benefits derived and whether these are optimized. Maybe if you could just give us an indication in terms of how far is the department in relation to this matter, and when are you expected to complete this process? Because I think even as members of the National Council of Provinces and this committee, we would be very interested in the outcome of that assessment. Secondly, Deputy Minister, I know you also indicated with regard to the registry, while there are various problems, it is not complete and it is compiled on the basis of what is being submitted. Perhaps maybe if you could perhaps also elaborate on why is this so, and what are some of these challenges? And the reason I'm also asking this question, Deputy Minister, is that okay, it's just hard. The fact that that provinces and municipalities are not necessarily following procedure, but obviously being the National Council of Provinces, we're also interested in this lack of intergovernmental cooperation. And if there's a need to unlock and unbottle some of these issues, we would obviously be better positioned to try and do that. And also, Deputy Minister, in our previous engagement, well, the department indicated that you have a role in terms of monitoring the agreements that or arrangements that provinces and or municipalities get into. I don't know how far is the department in this process, and also what are some of the challenges in terms of monitoring these agreements that provinces embark into. And finally, while it was explained that the department is responsible for certifying international agreements, but the tabling are done in Parliament by the line function departments. but also for a international agreement to be effective, in essence, there's a need for legislation and or legislative amendments. Otherwise, they're ineffective and yeah, they can't be implemented. But just in terms of this, I know the necessary legislation will be done by the relevant line departments. But what role, if any, does DIRCO have to ensure that? I know you have an interest in ensuring that the agreements are effective, but to what extent do you have a responsibility to ensure that relevant line function departments actually develop or amend legislation so that these instruments become more effective? Those are the questions from my side, Deputy Minister. Thank you. You may respond.
Chair, can I come back? Sorry for that.
No problem, Honorable Minister.
Thank you very much, Chair. Chair, you have reminded me on the issue of evaluation of the benefits of our agreements. Again, touching on the issue of intergovernmental relations. When they are doing this evaluation, and in the spirit of us being a unitary state, are they also taking into consideration the agreements that were signed by municipalities, the agreements that were signed by provinces, so that you have a holistic report of the benefits of agreements that we have? I know that we're not supposed to have as municipalities or else as provinces agreement, but the situation as it is now, they do have some agreements signed at that level. So it would be nice if there's a holistic approach of what are the benefits. Thanks, Chair.
Thank you, Honorable Minister. Deputy Minister.
Thank you very much, Chairperson. Well, I think our official will clarify the section 3211. I don't have my constitution with me here, but the issue of the conclusion of the assessment, I don't think we have got a date now or a time frame at present moment, because the process has just started. Remember, the past 25 years, the past 25 years, we didn't have a legislation that will compel provinces and municipalities to account directly to us. It is just now, after the passing of the Foreign Services Act, that we need really to make sure that we form the structures that we are speaking about, and also we assess, we collate all the information, as we are saying now, standing now, the list of all the agreements, we are saying it is not complete because municipalities were not sending to us. Those who were sending to us, we have information, but those who were not sending to us, we don't have information. We need to go to them and make sure that we get all the information. So the process is still going on, but because of we are covered now with the Foreign Services Act, which compel every spheres of government to via us on any interaction, on engagement with the international community. The issue of the IGR as well, as the Department of International Relations and Cooperation, we didn't have any IGR with any province or a department because we are representing the country. But in terms of the Foreign Services Bill now, our IGR that we're going to use is the forum, the consultative forum that will be forming, because all provinces and municipalities, whether they're represented by SALGA or represented by whoever, but will be sitting there together, looking at what we have, how far we have benefited or not benefited, and also start to look better together to see where we can go, where we can amass this project, where we can sign this agreement for what benefit that the province is going to get, the municipality is going to get. All those things will be discussed in that forum before any agreement or memorandum of understanding is signed. So I think it is a starting point because it was so lazy in the past 25 years. Those were accounting to us, understanding to us, they do that. Those were not, they were just moving around and all that. Like our officials are saying, some other agreement, we learn about them in newspapers, we learn about them, see them on TV. So it was just a very messy situation in that particular respect. But as it stands now, together with the oversight that the NCOP is going to give to us and also to provinces and municipalities, I think it will do a better work in terms of implementing the Services Act, the Foreign Services Act. Thank you very much. And the tool of monitoring, as we are now assessing, we still have to present a report, like I can't give the date, when are we going to complete the assessment, and when are we going to complete the list of agreements as well. So it's a process that is going on, but we are keen really to come back to the NCOP to give progress report of how far we stand and what is it that we have done until we have sorted out all the issues that we are speaking about. Thank you very much. I'll hand over to my officials to clarify the constitutional section 3211.
Thank you, Deputy Minister and Chairperson. Section 231, or let me say Section 231 in the Constitution has three subsections. That deals with the conclusion of international agreements in general. But 231 is specifically important because it states who can negotiate and sign international agreements. And that responsibility is specifically assigned to the national executive. The national executive, in terms of our constitution, consists of the president and members of cabinet. When it comes to a particular agreement that is within the responsibility of a specific minister and department, that minister would then take the responsibility for that agreement. And that minister, together with the president, would then constitute the national executive for purposes of signing the agreement. And that is reflected in a document that we call the President's Minute. All agreements must have a President's Minute. That is the instrument where the president then in writing confirms that South Africa will become a party to a specific agreement, and where a specific minister are given the authority to sign the agreement on behalf of South Africa. So that is your starting point of all agreements. If we have an agreement that's already in existence where signature is not possible, then of course the president will issue in any case a presidential minute to indicate South Africa will be bound by this agreement, and then that agreement will follow the parliamentary route for ratification or accession. Thank you, Madam Chairperson.
Sorry, Chair. I wanted Mrs. Devet to unpack, because what we have in our presentation is that we have unpacked section 3212 and 2313. So I think the question is, what about section 2311? I don't know whether you were unpacking that.
Thank you, Deputy Minister. Yes, I was specifically referring to section 2311 that says that the negotiating and signing of all international agreements is the responsibility of the national executive. And then I try to explain in terms of our constitution, who will be the national executives, because we do have questions around what in terms of our constitutional procedure we define as the national executive. And there the constitution also provides guidance. And in practice, what we have is that the president's minutes, the authority or where the president would indicate that or approve that South Africa becomes a party to an agreement is signed by the relevant line function department. That minister will countersign the minutes. So it is signed by the specific responsible minister, and then the president would sign the minutes. And on the basis of that, the agreement will then be concluded. It would then go through the binding process, and the parties will sign it. The responsible minister specifically authorized by the president to sign on our side, and on the other part's side, the particular minister that will be responsible that has been assigned in terms of that country's arrangements. Thank you.
Deputy Minister, are you?
No, I'm satisfied. I'm satisfied, Chair.
Okay. Now, I think I'm not sure if there's any other follow-up, but just in terms of legislation that needs to be developed to give effect to international treaties, what role does the department have around that? Because I don't think that question was responded adequately. But before you respond, Deputy Minister, I just want to ask honourable members first if they have any follow-up questions. And then if you could include that response as well. Honourable members, do you have any follow-up? Or do you feel the responses were not adequate?
I'm fine, we are fine, Chair.
Adequate, Chair.
Thank you. Deputy Minister, if you could just deal with that aspect of legislation.
Thank you very much, Chairperson. In terms of international agreement, I don't think there's any need of another legislation because of we are governed by the Constitution as a country and also governed by the international law.
Deputy Minister?
So now we will sit around and deal with international relations. At the end of the day, it must benefit South Africa and benefit the community in which that municipality is serving. So I don't think there's any new legislation that we can think about before we've exercised the implementation of the Foreign Services Act. Thank you very much, Chair.
Okay, thank you, Deputy Minister. I think our members, if we don't have any other questions that we would want to raise or comments that we would want to make, then let me take this opportunity to thank you, Deputy Minister, and your team for this presentation. We thought it would be prudent to have such a presentation. I think it's, in as much as we've dealt already with one international agreement, we didn't necessarily have such an engagement with the department. And I think, as I've said, that our interest is also in terms of what is happening in provinces. And we would like to get that kind of information. And we're hoping at some point the department will be able to assist us so that as we go down to provinces, when we do our oversight work, we're also able to look at the effectiveness of these arrangements that provinces have with other countries and municipalities. But just in terms of our engagement today, clearly we would be going forward, we would be interested in the implementation of the Foreign Services Act. Monitor this to a large extent, because clearly it unlocks the whole intergovernmental relations issues, and it ensures, that coordination and completeness of what is happening between national and provinces. And as you said, the assessment report, Minister, on the benefits derived from agreements, and these are optimized. Once this is actually complete, we would like to have a copy of that report. I think that as well will discuss as we do our oversight work. Yeah, but I think let me then thank you, Deputy Minister, and your team, and thank you, honourable members, for your participation in the meeting and this process. We still have a long way to go with the department, and I know you probably understand how we structured in the NCOP, Deputy Minister. We don't individual attention. I agree, but we try where we can, and as much as we can. But thank you very much, and thank you very much, honourable members. And let me then declare this meeting closed.
Thanks, Chair.
Thanks, Chair.
Thank you, Chair.
Thank you very much, Chairperson.